5 more tips for you to stay on your ERISA disability claim and continue to get benefits. Now, in the first part of this series, I talked about a number of things that you need to do. Read the policy, understand the terms of the policy, be compliant with your medical treatment, give your doctor a great history of symptoms and functionality, communicate with your lawyer. Now, let's talk about the next 5. If your disability carrier plan asks you to fill out disability forms, contact your lawyer immediately. Just because the disability carrier plan has accepted your claim doesn't mean that they're going to stop asking for information, and they're not going to stop looking at that information but to determine if you continue to meet the appropriate definition of disability. Now, just because the carrier plan has sent you that request for information doesn't mean they've always copied your lawyer. They're sneaky son of a guns. Remember that what you put on this form can make or break your case, so you want to make sure that what you're putting on that form is accurate and correct. Now, the next tip, that's number 6, would be if your disability carrier is asking your doctor to complete attending physician statement forms, make sure that your lawyer is looking at those forms, so they want to supplement them as appropriate, and make sure that the response is consistent with what's in your medical records. The next tip is going to be if the disability carrier or plan wants you to have a quote-unquote independent medical evaluation, contact your attorney immediately. I've had cases where they haven't told me that they're scheduling an IME, and my client has gone only to find out that that IME was not so independent. The next tip is a bit of the same thing, and that is if the insurance company or plan is requesting that you undergo a functional capacity evaluation, you should be on the phone with your lawyer to see whether or not, under even the terms of the policy or plan, that they have the right to have you undergo a functional capacity evaluation. And the last tip, of course, is to continue to be in communication with your lawyer at all times. Now, many lawyers, such as myself, do charge a monitoring fee, and that will vary from lawyer to lawyer. My fee is set up so that if you are, for example, in your own occupation stage, I continue to monitor for at least 2 years. But once you have, for example, gotten to the any occupation stage, and they're willingly, voluntarily, in quotes, paying benefits, I will ask my clients to pay a modest monitoring fee so that I can continue to make sure that what's happening in your case is appropriate, that the right information is getting to the disability carrier. So you can see that it takes teamwork. And I'll give you one little last tip. Stay off of surveillance. In other words, yeah, I'm going to give you just one little last tip. And that tip is don't post on social media. That's just fodder for disability insurance carriers or plans to put surveillance on you and question your continued right to get disability benefits. If you have any questions about your rights to disability insurance benefits, or your claim has been denied or terminated, contact me today at 727-894-3188 for a complimentary consultation. I can help you regardless of where you live in the United States. Now, as you see, I did a blooper there, so cut that blooper out and put the, paste in exactly my filler, if you will, and I apologize for that. Thanks.